Thank you for joining us today. Welcome to the Shasta Trinity, Shasta-Cascade, Shasta-Cascade SBDC. We are here today talking about hiring and firing first things first. This is the Linda Show. I am Linda Fitzgerald, your host, and soon I will introduce you to Linda Sinyard. But first, let's get things started and let me share some things with you.
Hold on. Sorry.
That's okay.
For some reason, my arrows aren't working. How is that possible?
What about your keys on your keypad? There we
that's
go.
what I was using.
This is the Shasta-Cascade Small Business Development Center. We're a nonprofit organization through the government, and we are funded by the U.S. Small Business Administration and the HSU sponsored foundation. And we are so glad that you're here. With the beauty of the webinar, we are able to cover so much more territory than just Shasta and Trinity counties, which is who we serve in person. What we would like you to know is if you are in Shasta or Trinity County and you would like to meet one-on-one with either Linda Sinyard or another advisor for the SBDC, you can do that. And this is, we're going to have a slide at the end to share a little bit more about that. The service is paid for with your tax dollars, so there is no direct cost to you. We provide confidential, no-cost advisory and training services to small businesses.
No, seriously, Linda, I'm not kidding. My directional buttons aren't working.
Oh
so hang on just a minute.
We'll be
I'm going to have to do this with the mouse, which is going to be kind of iffy, but let's go.
Well, these days we learn to adapt, don't we? I'll start with our disclaimer. The information provided in this webinar and any supplementary materials provided to registrants are intended for educational and informational purposes only and does not constitute professional, financial, or legal advice. No registrant should act or fail to act on the basis of any material contained in this webinar without obtaining proper financial, legal, or other professional advice specific to their situation. The Northern California Small Business Development Center and its host, the HSU Sponsored Programs Foundation, specifically disclaims any liability, loss, or risk, personal or otherwise, which is incurred as a consequence directly or indirectly of the use and application of any of the information presented in this webinar. And now I would like to present to you Linda Sinyard, who will be your presenter for the day. I will be operating as the host, managing the chat. And Linda, please take over.
Sure. Thanks, Linda. Thanks for the introduction to SBDC. Okay, so I've worked in human resources for a little over 26 years now. And prior to that, I was a legal assistant for about 9 years. But prior to that, I was an operations manager, and I've been a business owner off and on for, I don't know, decades now. I have 2 national certifications in human resources. One is called the SHRM, or the Society for Human Resource Management, Senior Certified Professional. That's a really long title, which is why I just always use the SHRM SCP. And something called the Senior Professional in Human Resources certification. That one's been around a lot longer. Educationally, I have a bachelor's degree in organizational leadership, which is basically covers most everything in human resources, but then with a huge emphasis on leadership, and a master's in transpersonal psychology. That's what we call the good psychology. And then I'm working on a PhD in what's called thanatology, which is the study of dying, death, and grief. That's a little bit about me. Oops, and here we go. The agenda for today. So first, we're going to have introductions of people who are joining us today. Then we're going to cover hiring, firing, Q&A, and then a wrap up. By the end of today, by the end of this webinar, you'll be aware of the requirements and best practices for hiring and firing, and then when to contact a human resources consultant or an attorney. Generally speaking, small, medium, and large companies will work with a human resources department in-house or an external consultant before they go to an attorney. We're a little less expensive, and we get what we call the best practices portion of it, not just the legal side. So who would like to share a little bit about themselves? You, your business, your idea for a business, and your reason for being here. Anyone want to chime in?
And you're welcome to turn on your microphone to participate. If you don't have a microphone or for some reason you're not able to turn the microphone on, you're welcome to share in the chat and I'll be happy to read that for you.
Hi, I'm willing to share. My name's Aloha Lani, and I'm in Arcata, California, and I am the office manager of a small zero net energy consulting company, and we have just been hiring mostly, students from HSU, and have only been 3 full-time employees. But now we're starting to grow, so I'm here to learn more as we start putting out more ads for hiring new employees, and just growing. Our business has started to grow, so we need to make sure we're following up all the laws and whatnot. Thank you.
Thanks, Aloha Lani. You make a good point. You're an office manager, and that's where a lot of people, small businesses particularly, they don't have an HR department, they don't have an HR manager, they're just not big enough. And it's up to you to learn these rules. So yeah, thank you for joining us. Anyone else?
I have one in the chat. It's my name. Oh, I have a couple in the chat. Let me scroll back here and read them all for you. Hello, I am Sarah from the Hotel Arcata. I've been the controller for over 30 years and have joined today to find out if there are any changes due to COVID. And the next one is, hi, my name is Michael Stearns. I am an HR director, among other roles, for a restoration-based nonprofit, the Mid-Klamath Watershed Council in rural and remote Orleans, California.
Okay. Anyone else before we move on?
Here's one. My microphone's not working presently. It says I'm an owner of a cold pressed juice company in Arcata out of a commercial kitchen. I'm getting ready to hire for the first time in a while, so I just wanted to touch base. I'm a one-stop owner operator. Lots of folks are hiring right now, and I'm just looking for more info with the new COVID environment.
Okay, great. So that's the second time we've heard COVID mentioned, and I need to tell you that this particular presentation doesn't cover any COVID-related business activities as far as employment, except in a couple of places, because the laws haven't changed around hiring and firing with COVID. Those two things have stayed pretty much the same. Being at work, how you're at work, interviews, you'll see in the slides. So we'll talk about that. Anyone else?
Yes. Another entry in the chat is, hi, I do nonprofit consulting for fundraising events and need to make my first hire, likely an intern.
Okay. So if I don't remember to get back to interns, because that's not a part of this slide, somebody put it in the chat to ask me about hiring interns. It's a whole different thing.
Holly's the one that posted that. Holly, can you make a note? We're going to be in this webinar for an hour and a half. So can you make a note to tap into that a little bit later and put a message in the chat? Thank you. Okay.
Shall I move on, Linda?
Yes, please.
All righty. So the first thing is create a job description. And that might sound like it comes later, but it really is the first thing. The reason is you as the business owner or as the person who's in charge of hiring, you need to assess the necessity. Do you actually need a person? So for those of you who are saying you're hiring your first person, make sure you know that it's time and you really need that person, because this gets expensive, hiring your first person. You need to know what the job is worth. You need to know the scope of the job. How big is the job? Which pieces are you going to keep? Which pieces are the new hire going to take? The job description clarifies for other managers or you and the new hire certain things like, are they exempt or non-exempt? And people get very confused with those words. Exempt simply means you're exempt from overtime. You're on a salary. And non-exempt means you're not exempt from overtime. You are eligible for overtime. So these are hourly employees. You need to know what the essential functions. That's actually kind of a legal phrase that they use in job descriptions, because it has to do with not just what the person does every day, but what's essential. It's not going to cover everything. It never does. It can't. You also need to know what are the knowledge, skills, and abilities of the person that you want to hire. The qualifications. This is one that gets confusing because people often put in the qualifications more than is actually required. So I'm sure you've all seen job descriptions or job postings on, job boards or hard copy where it says college degree required. And I think there's sort of a misconception about that. That may be nice in a lot of jobs, and it may actually be required in some jobs. But typically, a college degree, and this has changed over time, by the way, a college degree is required for things like licensure. Particular certifications will require it. So a doctor, obviously, lawyers, yeah. And there are actually 3 states in the country where you don't actually have to have a college degree to become a lawyer. If you can pass the bar exam, you can be a lawyer. It happens extremely rarely. But be careful about putting in more qualifications that are really needed. And if you do feel like you need to have higher qualifications for screening purposes, go ahead and put them in, but you're going to get people who are going to apply without all those qualifications. They might know how to do the job very, very well. The physical requirements. You should have in your job description physical requirements, such as if it's a job that's very, very physical, you'll want to put in there that, walking in the heat, walking in the cold, outdoors, noise levels, things like that. And then you want to put this phrase in there, with or without accommodation, meaning the person may have some physical challenges, but with particular accommodations or devices or apparatus could do the job. So you want to put that in there because that also is a piece of the Americans with Disabilities Act. You don't want to discriminate just because someone doesn't have the exact same physical abilities as maybe another applicant. And then the work environment description. Work environment description, if it's an office job, you just say office environment. If it's a warehouse, you want to say warehouse and include heat and cold, cement floors, things like that. The job description also supports your performance standards. So when you're looking at review time and you want to share with your employee how they're doing on the job, sometimes you will actually refer to the job description, particularly if they're not meeting the challenges of the job. Also the job description is the foundation of the job posting. Oops, sorry, I'm really sorry. I'm having to use my mouse for advancing the slides.
Linda?
Yeah.
I just want to address one thing that someone asked about. They said, will we get the slides? We are recording this, and in a couple days you'll receive an email from Emily with a link to this presentation. So you will be able to look at the entire presentation again. Linda, will the slides be shared with them as well? Is that something I can ask Emily to share?
Yeah, absolutely.
Great. Okay, thank you.
No problem. Sure, thank you. Thanks for jumping in there. So you need to define your worker classification. And this is what I was just talking about with the exempt or non-exempt status. This is something that is governed or enforced by the Fair Labor Standards Act. You can find the actual description at that website, DOL, which stands for Department of Labor, and WHD stands for the Wage and Hour Division. The Fair Labor Standards Act exemptions to overtime. These are people who can be salaried. No overtime needs to be paid. And there are 6 different categories. One is executive, one is administrative, one is called professional, one is computer professional, which is separate than professional. It's specific to like software design. It's not just computer users, or else every single person who uses a computer would be exempt from overtime. So that's not the case. And then salespeople, and these are not inside salespeople. It's just external, just people who are actually on the road, in airplanes, in hotels, going to sales conferences, and actually going out to meet customers, which, by the way, that number is decreasing all the time. And a lot of that just has to do with the fact that it's incredibly expensive. Of course, during COVID, nobody was traveling, so everything was done by Zoom or another video conference. But that's still, outside salespeople are exempt from overtime. Misclassifying somebody as exempt or non-exempt is incredibly expensive. Having been through 2 of those Department of Labor audits in my career, and I'm thankful it's only 2, it's very expensive. The US Department of Labor can charge a company 2 years of back pay for overtime, plus fines and penalties. Incredibly expensive. That while the US Department of Labor doesn't actually, they don't call up the California Department of Fair Employment and Housing, but an employee who's aware that it's also against California laws, it's not just federal, can certainly make a claim with the California Department of Fair Employment and Housing. And if the audit approves that the company has misclassified employees and not paid overtime when they should have, then the California Department of Fair Employment and Housing charges 3 years of back pay plus fines and penalties. So when you add all that up, you're talking about a whole lot of money. So while I get calls all the time, people saying, well, so-and-so, my new hire wants to be just paid salary. They don't want to have to punch a clock, time clock, or fill out a time card. That's not a reason. That is not a reason for choosing salary. So you want to be really careful about that. Look up those fact sheets. It's the second link in this slide, the WHD fact sheets, 17A overtime. So also with worker classification, you want to make sure that you are, and again, did I go too far? I did. That you're classifying, no, I didn't. Okay, sorry about that, guys. Independent contractors. So what we just talked about was employees with exempt and non-exempt. There's no such thing with independent contractors. However, independent contractors are a very risky area nowadays. It's always been governed by the IRS and state laws, different laws in each state, of course. But now, since January of 2020, we have what's called AB5. We'll talk about that in just a second. So the Internal Revenue Service has a publication that defines the difference between independent contractors and employees. As a matter of fact, there are lots of screens that you'll look up in the IRS. The IRS has very similar definitions to California and most states, but in some states, they're even more rigid. The IRS is more rigid than the state laws. That's not true in California. California has one of the most rigid laws around independent contractor, and it is called California Assembly Bill 5. You'll hear people constantly nowadays say, oh, AB5, AB5, AB5. So one of the best examples, or the best articles that I've found on it, without all the legalese, but putting it in real person terms, is at Nolo Press. So just go to nolo.com and then look up AB5. There are some new exemptions. I believe the Assembly Bill number is 2257. I don't pay much attention to that number because everyone is still calling it AB5. So the new exemptions, they have finally this year, January of this year, excuse me, exempted some people from the independent contractor, the new classifications. It's called the ABC test. So some people who last year weren't able to function as independent contractors again are able to function as independent contractors. These folks, if you do hire independent contractors, they go on, the tax form that they fill out is a W-9. The tax form that you as the employer fill out is a 1099. If you work in industries that use lots of what we call gig workers or independent contractors, you'll hear people constantly say, oh, are you a 1099 or a W-2? A W-2 is the form that comes at the end of the year from an employer with employees, and a 1099 is for independent contractors. The misclassification risks and penalties are extremely high here too. They're different than the misclassification risks for exempt and non-exempt. These risks include tax laws, retirement plans, workers' compensation laws, because you're not covering independent contractors with workers' comp, and unemployment insurance laws. Yes, I have actually gotten unemployment insurance claims from people who were real, legitimate, independent contractors in the past. And then what happens is you get audited to find out if there was a misclassification, if the company actually messed up and made someone an independent contractor. And one of the most frequent reasons is, oh, well, I didn't want to pay payroll taxes on them. I didn't want to cover them with workers' comp. So they were okay with it. Not legitimate. Then the statutory employment laws. People who are independent contractors are not always covered by the Equal Employment Opportunity Commission. In a lot of cases they are, but in some they're not. Independent contractors also are not always covered with the Americans with Disabilities Act. Should they be? Yes. In most cases, are they? Yes. Age Discrimination and Employment Act, same thing. It's very hard to file a claim about age discrimination if you're an independent contractor. Family Medical Leave Act. Independent contractors have no rights to FMLA. And that really hurts if the independent contractor becomes sick or has a family member who needs assistance while they're sick. They're not covered by leave of absence rules or reasonable accommodations. So you don't actually have to accommodate a person who's an independent contractor if they have any kind of physical or mental challenges that normally would be covered under the Americans with Disabilities Act. They're also not covered by wage and hour laws. And lots of times you'll hear them say, well, I worked 12 hours today. It sure would be nice if I was an employee, so I would get paid overtime. Federal and state taxes is the next thing you need to do when you're going to hire your first employee. You need to get an employer identification number from the IRS. Some people call it an FEIN, Federal Employer Identification Number. Some people just call it the EIN, and it's form SS4. Go to the IRS website and just search for form SS4. There is a fee associated with it. It's not very expensive. I think it's around $250, something like that. And then you need to establish your California payroll tax account. This is where you go to the Employment Development Department, the EDD, and scroll down. It's on the left side of the home page, and it says Employer Business Forms, something like that. And it'll say New Businesses. And where the New Businesses section is, you want to open up all of those screens. And you will have to get an employer identification number for California as well. Workers' compensation. This is the one that kicks a lot of small businesses out of the idea of even hiring somebody. It is incredibly expensive depending on the type of work. So workers' comp insurance is required with your first employee. You do not have to cover yourself. Owners are exempt from workers' comp. You can add yourself, but you're going to pay a lot of money. And you don't, and you know, what do you want to file a claim against yourself? Well, yeah, sometimes you would. If you fall off a ladder and are seriously injured, you might want to consider that. So your first hire, you have to get workers' compensation insurance. And like I said, depending on the type of work, if it's physical activity, if they have to drive a forklift, if they climb ladders, if they're stage hands and they do rigging for, you know, lights up in the air for stages, those kinds of jobs are incredibly expensive with workers' comp. Let's see. and everyone, I'm making a bad assumption here, but workers' compensation is for workplace injuries and illnesses. If an employee files a claim for workers' compensation, it's going to cover time off work. It doesn't cover at the same pay rate, but it does cover as what we call supplemental income. It covers their medical bills, their prescriptions, mileage reimbursement to and from their appointments, and half the people I've worked with over the years have completely forgotten about that fact. And if you're living in a rural area like a lot of us do up here in Northern California, it can be a long drive to and from your appointments. So yes, mileage reimbursement is part of it. If the person is eligible, if the injured party is eligible, sometimes their future medical bills will be paid for by workers' compensation claim. And then medical settlements. This is at the end of the claim when the person is ready to return to work. They may have lost some or a lot of their abilities, range of motion, the use of a hand, the use of a foot, we don't know. And so the workers' compensation will actually pay out a settlement. Some employees are going to hire attorneys regardless of how simple the claim is. It's just that they don't know the system, they don't trust it. They're afraid they're going to lose their job because they filed a claim and it costs the company money, which it does. And so they hire attorneys to protect their rights. There's no harm in that. I actually think it's a good idea. But from the employee perspective, it's kind of alarming when you first see that they've hired an attorney. They're not actually arguing anything. They're not disputing anything. They're just protecting their rights and they don't know the system. That's the majority of them. Payroll systems, number 5 on hiring. Payroll systems. Outsourced payroll can be less expensive in the long run. I always laugh when I read this to myself, even though I wrote it, because most people say, what, I'm going to pay a payroll company and you think that's less expensive? I'm already paying mandatory payroll taxes. Yeah, you know how it's less expensive? Because when you mess up a paycheck and the employee files a claim because you couldn't correct it fast enough, yeah, you can be charged fines and penalties. So I've been to the labor board on this a few times, and it almost always happens with final paychecks. Final paychecks in the state of California. You have to pay the person on the day you fire them, by the end of their regular business day. And that means that you've got to collect all those hours, or if it's salary, do the calculations for what part of the pay period you're paying them for. And then if they've given notice, if the person has given notice, you actually have up to 72 hours to pay them their final paycheck. Most companies that I've ever worked with, and that's a lot, pay everybody on the final day in California. Automated payroll systems will calculate the employee and employer taxes. This is another place where it can be less expensive to have outsourced payroll. If you are not 100% correct, then you can get charged by the state or the feds for not paying the correct payroll taxes. Automated payroll systems will also calculate wage withholding orders. If you're not familiar with that term, you probably are familiar with the term garnishment. So the most frequent garnishment orders I have received over the years are for back taxes. They will come right after the employee's paycheck, and child support. Those are the most frequent. Sometimes it's outstanding bills, but it's rare. Manual processing is legal. You can do your own paychecks. You can actually sit at your desk with a calculator and calculate the different categories of mandatory payroll taxes and do it yourself. You must give your employee a paycheck stub that shows exactly how much is taken out of the paycheck for each category. And this is, Social Security, Medicare, unemployment, in our state disability, and a bunch of others. Then you want to post your open position. So posting your open position should not be just posting the job description. The job description at the end, in the worst case scenario, it's a legal document. It's got too much information in it to be an actual marketing tool. And what you want your job posting, where you post, whether it's, LinkedIn or ZipRecruiter, Indeed, Glassdoor, it doesn't matter where you post, it needs to be a sell sheet. So when I say sell sheet, this is very much like in real estate. You'll see those flyers outside of a house for sale. That's a sell sheet. You use your job description as the basis for the posting, but it needs to be a marketing tool. You need to have information in the posting that makes your company sound inviting. You're selling the idea that your job is the job the candidate wants. One of the places you want to look for new employees is employee referrals. There are some companies that still don't want to do employee referrals. They think to themselves, oh, I don't want a bunch of friends working here. Well, guess what? If I am an employee and I think one of my friends or even a family member that won't report to me is a good candidate for a job, I do want to refer them. Now, would I refer them if I thought they were a bad candidate? No. And that's why employee referrals are one of the best ways you can find new hires. It's not a bad idea. It's actually an excellent idea to give an employee referral bonus if you can afford it. Throw $100. There are companies out there that'll pay up to $5,000 for employee referrals. Granted, those are huge, giant, multinational conglomerates, but it's a good idea. It just says thank you. Online job boards, Indeed, ZipRecruiter, LinkedIn, Glassdoor. There are so many of them nowadays, and you want to use association job boards. So I work in human resources. If I were on the job market and looking for a job, I would go to the Society for Human Resource Management, otherwise known as SHRM, and that's where I would look, because that means that the person, the business looking for a new HR director or VP of HR knows that that association, most of the people who are going to look for jobs there have all the certifications. They've done the training. They've spent all the years doing all the continuing education. So same is true for product marketing, engineering, software developers. It's a good idea to post specific to their trade. Craigslist, yeah, Craigslist kind of put newspapers, the classified ads, out of business over 20 years ago. I remember when it happened, and at the time, I was living in San Francisco, and Craigslist was actually down the street. It was in an old house. There were only 20 employees, and it became explosive. It was a great place to go for jobs. Now, you're not going to, generally speaking, that's not where you're going to go to find extremely experienced people in specialty fields. You're not going to go there for higher education jobs. Typically, once in a while, you'll get lucky. And up here, most of our cities, I think Sacramento has to pay a fee, but most of the cities up here in the North State, it's free to post there. And then network. You want to network your jobs. So you go to your trade associations. Like I said, I'm a SHRM member, so I would go to my local SHRM chapter now that we can go back to in-person meetings, and also the Chamber of Commerce. Talk it up. Anywhere that you see people, talk about the fact that you have job openings. The application is in fact a legal document, and it follows certain rules. California, again, has a lot of rules around applications. We have statewide requirements, and some of our individual cities have additional requirements. There's something like 11 cities and one actual neighborhood in the Los Angeles area has its own unique laws around employment. So you want to make sure that your employee application is the appropriate form for your area. It also has what's called an applicant attestation clause at the end. This is the part that says, I've read and understood everything I filled out on this form is, accurate to the best of my knowledge. And then they sign and date it. That's what makes it the legal document. That's what makes it so that if you find out that they actually have falsified the application, you can actually terminate based on that. You can terminate based on so many things now. So you want to make sure that you have the appropriate application. If you hire the person, you want to keep that application in their employee file. It is a part of their permanent file. If you don't hire a candidate, and this will be most of the applications, you keep the applications in job title files. So it'd say human resource manager, that's the file name. And everybody who wasn't hired would go in there. And you keep it for, and I say blank, because it's up to you. It's not even required. You don't have to keep them. However, if you ever have a claim for any type of discrimination in hiring and you get audited, the auditing agency will go through all of your old applications to make sure that you did not discriminate against someone. So most people keep these on file anywhere from 6 months to 2 years, and some even longer. 7A, the interviews. So you need to choose your type of interview, whether it's on the phone, by video, or in person. During COVID, nobody was doing in-person interviews except for the essential function jobs. The video interviews became pretty much the norm. And because so many people were working from home, it was also sort of a good audition, so to speak. A lot of people are incredibly uncomfortable with video interviews. I remember the first time I did a video interview for a job, and I just felt odd. Like, why, I didn't want anybody seeing my room, like my room right now. This is my little tiny office, and it's under construction. So, people looking for a job are very, very concerned about such things. And then the types of interviews, whether it's structured, which means heavily scripted, behavior-based, which is the most common nowadays, by the way. It's where the interviewer or interviewers are asking questions about your past performance. Tell me about a time when. That's a very common intro to a question for a behavior-based interview. Or describe for me your favorite manager in the past and why. So they want to go to past behavior because it's believed that past performance is the best indicator for future success or future performance. And then situational, this is very common in safety type situations where they want to put the candidate in the situation that would be experienced at work. So they'll describe for you a very common thing. Let's just use falling off a ladder. You're interviewing for a safety director, and they want to know what are the steps you take when an employee falls off a ladder. So then you talk, about not just historical, as in behavior-based, but also what you would do given this new environment that you're going into. Then panel interviews with as many as 15, and I'm not kidding, 15 people interviewing me. It's incredibly stressful because you have no feel for the person asking the question. These are typically very structured interviews, very regimented, with numbered questions and the interviewers' names aligned with the questions. Very stressful. And then there's a natural interview style called a stress interview. This is typically for high risk jobs, rigging, firefighters, police officers, sometimes healthcare organizations will use stress interviews. And then serial interviews. Google is famous for having more interviews per person than anybody else on the planet. They've cut that back in the past couple of years, but serial interviews are incredibly taxing on the candidate, especially if travel is involved. You may have to come back literally 6 times for an interview. In your interviews, you want to steer clear of anything that might be considered discriminatory in your questions. Hello?
Yes, I have a question in the chat.
Sure.
I would also like to know what I can ask and not ask in checking references. And the reverse, what can I answer or say when someone calls me about a past employee?
That's a great question. And it's actually a very, very long answer. So let me get to the bottom of this slide and then I'll go back to that. So you want to steer clear of everything that's in the Title VII of the Civil Rights Act. That's race, sex, color, national origin, religion. There are a few more in there, but know that California has even a longer list, which we'll see in a minute. You want to steer clear of anything that could have to do with physical or mental disabilities, with age, and something called ban the box. This came in a few years ago. You cannot ask an employee about their past criminal history until an offer has been made. And then in the background checking process, that question can be asked. And if you use a background screening service, they will actually get an authorization from the candidate, from the person who's been made an offer, to check on their criminal history, among a bunch of other things. Also, newer to California, we as employers cannot ask the salary history of the person who's interviewing for a job. The reason is it actually is disruptive to the Equal Pay Act, which came in 1964, and millions of people still don't know about it. And in California, the Fair Pay Act, which only came in a few years ago. So we can't ask about salary history, because what happens is they'll say, oh, you'll ask somebody, typically, and this is just the truth, and this is why this is a prohibited question anymore. It's typically women who will say, you know, when asked the question, they'll tell you the real number. Oh, I made $60,000 at that job, and the one before it, I made $55,000. And then the company will say, oh gosh, we were going to pay 75. Well, we don't need to pay her that much. And then what happens is it violates the Fair Pay Act, because you're not basing it on what the job is worth and what people in the same or similar jobs are being paid. And typically, that's where we saw a gender gap. And that's why it violates both the Fair Pay Act and the Equal Pay Act. So the candidate can tell you, sometimes the company will just ask, well, what are you expecting to be paid? And that's fine. You can ask that. And the candidate can tell you. That's not a problem at all. And then no questions about sexual orientation, gender identity, or gender expression. So if you're not familiar with all of those phrases, sexual orientation is how the person, at birth were identified. Gender identity is how they identify now. And then gender expression is a very difficult thing for lots of folks, in that it may be that your dress expresses how you see your gender. It may be that your hair expresses. It may be mannerisms. It may be your voice. So many things come into it. So just steer clear of any questions that might be taken as discriminatory by the candidate. So back to reference checking real quick, because I didn't put that in here. That like I said, it actually is a whole training in and of itself. What questions can you ask when you're checking references? Really very few now. You can ask, you cannot ask the salary anymore. For years, we could ask the salary in reference checking. We can ask the title, the dates of employment, and would they be rehired? That's about it. It used to be a much longer list. And the reason is it can be found as discriminatory. So if you ask too many questions, and seriously, there are lots of folks who ignore this whole piece of reference checking completely. They ask all kinds of questions. I've worked for plenty of bosses who say, no, I don't want you checking references, Linda, because you're only going to ask the questions that are, allowed by law. And I want to know what the real story is. I'm going to do the reference checking. And, that makes me really nervous, because I have no idea what they're asking in those phone calls. Or sometimes they even take the person to lunch, the former boss to lunch, and ask questions, depending on, of course, how high level the job is. What you can answer, those same things. You can answer the job title, dates of employment, and would you rehire? I would not be surprised if at a certain point in time, we can't even ask, would you rehire? Because there are but a lot of people who, through no fault of their own, have lost jobs, layoffs, reductions in force, and companies actually adopt policy to say, we don't do rehires, period. We don't have anybody come back. So it's not anything that's really against the employee. Was there another piece to that question, Linda?
Yes, let me go back and look. And I have some other questions that follow up that one, but let me go back here. Here it is. I would also like to know what I can ask and not ask in checking references, and the reverse. What can I answer or say when someone calls me about a past employee?
Okay, so okay, I did cover it then. Here's the other thing. A lot of times now, companies, because of all of these rules around reference checking, a lot of people, and myself included, I don't do background checks anymore. I don't do reference checks. I hire an external screening service, background screening service. They have all the legal documentation. The candidate has actually signed saying it's okay for you to check my background. And I leave it to them to give me the report that says, you know, all the things I need to know. So is it an expense? Yeah. Is it very expensive? No, it's not very expensive. And when you consider what it might cost you if you mess this up, it's a great idea to go through an employment screening background service. Just Google it. You're going to find tons of them in the state of California.
Okay.
Any other questions on that?
I do. I have a few here. I love this question. Can we ask vaccination status related to COVID? Can we hire based on that, or is that discriminatory?
That is such a gigantic question. I have been reading for months now, of course, on the rules. We don't have exact rules yet. They're changing constantly. The only thing I can tell you is, I mean, yes, you can ask. Yes, they can refuse to answer. Can you deny employment based on that? We really don't know. Honest to goodness. Every time I open another article, and I get articles from OSHA, from the CDC, from the state of California, from the public health departments in various counties, it's all over the map. So I wish I had an answer for you, but I don't. I mean, there are articles about companies that are requiring vaccinations, except for people who have accommodations, either religious or medical reasons why they can't get the vaccine. Whether it's legal to say, no, you can't come back to work then. We don't know yet. Some articles say, yep, it's legal. Other articles say, the jury's out, and we're going to have some of the newsletters I get from law firms. They're expecting there to be tons and tons of lawsuits over this question. So I wish I had an answer for you. Next question.
The next one of our attendees works at a very large educational institution that we would all know, and they were asked their past salary. So they're curious, when did that you can no longer ask a past salary question change?
I can't give the exact date, but I'm pretty sure it was either last January, that would be January of 2020, or it might have been January of 2019. I'm sorry, I don't know.
Okay, but within the past 2 years, if they were hired 5 years ago, it would explain that it was.
Oh, 5 years ago, yeah. 5 years ago, yeah. We were still asking.
Okay. And the last question I currently see in the chat is, what about letters of reference? Is that a good idea to give them?
Almost no company that I've worked for in the past 10 years will even do them. And there's a reason for that. One of the reasons is that those letters of reference are often favors. Are they really accurate? Sometimes they're given as part of, sort of a going away gift, so to speak, part of a severance package even. Very few companies that I've worked with in the past, I don't know, 10 years for sure, but I want to say 20 years, don't even write them anymore. They're not verifiable. That's the reason. So what do they mean to a hiring manager? Very little. And that's not just human resources that it's hiring. That's the actual department managers. The letters of reference don't mean much anymore.
Yeah, the follow-up from that same attendee is in education, they expect you to have them.
Yes, and that's true. Same thing when you're, applying for admission to a school, they want letters of reference. Well, I'm sorry, it's just sort of an old-fashioned formulaic part of the screening process. The thinking is, having been to many, many educational institutions, the thinking still is that no one would write you the letter unless you were a good candidate for admission to a university or for a job. Well, maybe so, but I'll tell you what, I asked one, this was for admission to a school. This was a very, very long time ago. I asked someone and she wrote me the most glowing letter of reference, and she knew nothing, and I mean nothing, about my ability to get through a master's program. So what's it worth? I don't know. And yes, it's very, very, very traditional in a lot of different institutions.
Another request is, then what do you do if you're asked for a letter of reference?
You can just say, I'm sorry, we don't do them. Or you can write it. I mean, that's just a personal choice. There's no rule around this. There's no laws. So it, depends. How do you feel about it? But I'll tell you what, if you write one for one individual, you're going to write them for everybody who asks. So, I mean, I don't write them. I never write them for anybody. I haven't written one in, like I said, it's somewhere between 10 and 20 years.
And we have cleaned out the chat questions. Thanks, Linda.
Okay, so another thing I want to say here, let me just check the time, is this is an incredibly long training, and we might have to save the questions and I'll answer them by email, or you can call me afterwards because we're not even halfway through. Offer of employment, offer letter with specifics. So you do want to write offer letters. You want to have the job title and who the person reports to. You need to have the start date, whether they're exempt or non-exempt, remember, salary or hourly, whether they're full or part-time, whether they're temporary or seasonal, and you never put you never say this is a permanent job. You can say it's a regular job, but you don't use the word permanent because nothing's permanent anymore. You need to have the annual salary for exempt employees. And if it's an hourly employee, you need to put in the hourly wage, plus you need to have what that would be on an annual basis, plus the overtime rate, which I hope everyone knows is 1.5 times the regular hourly rate. You need to have in there what paydays, when the paydays are, a brief synopsis of the benefits, if you have, if you have benefits, and then the at-will clause. I'm guessing most of you have heard of the at-will clause. It means that the either the company or the employee can leave or be fired or quit with or without cause. In other words, you don't have to give a reason. You don't even, it's, everybody thinks, oh, well, you have to give 2 weeks notice. That is a custom. It's not a rule. And then if the employee is non-exempt, you might want to just not write the offer letter at all. There's a form, just Google this. It's called Form 2810.5. And it has all the required pieces that are in these bullet points that would be otherwise in an offer letter. It also has in there who the workers' compensation carrier is. So if you're doing an offer letter, if you're bothering to write up one for hourly employees, then you need to have your workers' comp carrier in there as well, and the contact information for that carrier. New hire forms, W-4, this is the federal tax withholding form that every employee has to fill out. The DE-4 is the California version. Some people actually claim different exemptions on their federal and state withholding taxes. The DE-35 is just a notice to employees, and that's actually what it's called, notice to employees. It's from the Employment Development Department, and it basically just says, here are the things that you will be notified about regarding your state taxes. The I-9 is the Employment Eligibility Verification Form. It comes out of the United States Customs and Immigration Service. This is the one that says they either are a citizen of the United States or they're authorized to work in this country by virtue of, and then there's a list as long as my arm of the different documentation that can be asked for to provide proof of eligibility to work in this country. You never want to keep your I-9 in an employee file. You always keep these in a separate file or a binder, not in employee files. There's historical reason for that, and it's that employee files can be audited for many, many different reasons, and you don't want to encourage anyone to view citizenship or authorization status in an employee file when discrimination is so rampant. And then company specific forms, you want to keep those. This might be a non-disclosure agreement, it might be a non-compete, it might be your security policies, it might be specific to IT or safety. So any of those forms you can keep in the employee file as well. Benefits enrollment forms, a lot of enrollments are just done online now, but benefits enrollment forms should also be kept in a separate file. Anything medical, keep it out of the employee file. And then the employer has to file. So for those of you who are hiring your first people, your first hires are coming up, you're going to file a form called the DE-34. It's the report of new employees. This goes to the Employment Development Department, and it is specifically used, but not solely, specifically used for back child support payments. The Employment Development Department actually uses that form and notifies the counties of who new employees are, so that if there's a wage garnishment for child support, they know where the employee is working. More new hire forms. So there are required pamphlets in this state that you have to give, I should say pamphlets and notices, that you have to give to all new hires. You can look up each one of these online. Disability insurance provisions, paid family leave insurance, time to hire, sexual harassment, for your benefit, and victims of domestic violence. That one doesn't have a number. You just look it up under the Labor Commissioner's Office or the DIR, Department of Industrial Relations, online. Or you can probably just look up California Victims of Domestic Violence Notice, and that is just a notice. It does not come in pamphlet form. You can also purchase these, the pamphlets through California Chamber of Commerce. Required notices. These are notices and posters. So the notice, the reason it's called notices is because they used to all come in separate individual 8.5 by 11 pieces of paper. Now they're gigantic posters, and they combine the federal and the state laws that all employees have the right to know. So federal and state labor law posters, you can purchase them from a lot of vendors. Just look up federal and state labor law posters. But the Cal Chamber has packages where they send you the poster and all those pamphlets that we just went over. So these posters have to be located where all employees can see them. They're typically in break rooms, lunchrooms, and bulletin boards in main hallways. I'm sure you've all seen them. And by the way, they change every year. And when new laws come out mid-year, usually July, if you have one of the poster services, they'll send you a new poster. Employee handbooks, safety programs, and IIPP. Employee handbooks are not required by law, but it's really not smart to not have one. You want to have an employee handbook, even if it's very, very simple at first. It not only is what we consider a best practice, but it will be used over and over and over. I can't tell you how many times employees have come to me and said, hey, it says here in the employee handbook that blah, 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 and I'm not sure that's happening. And then that's a really good time for you to review, well, is it in the employee handbook because it's required? Is it in the employee handbook because it's something that want to have happen at our work. It's part of our culture. It's part of our safety practices. What is it that you want to express in there? The Cal Chamber, again, Cal Chamber has what I consider an excellent template product. If you have a law firm create your employee handbook, you can spend anywhere from $1,500 to $5,000. I'm not kidding. The last one that I got from a law firm, which was Littler Mendelson, and this was, gosh, like 2014, I think, was $5,000. Incredible. Or you can go to Cal Chamber, spend $250 and get their online tool. It's templated with 3 categories. Mandatory. If you're going to have an employee handbook, there are certain things that are required, but you don't have to have one at all. So if that makes sense. So the sections will say mandatory, and you can't change those sections. And then it'll say recommended, and those you can edit. And then optional, totally editable. Is there a question?
Yes. There's a question of employee posters, and I think it goes with handbooks as well. If your employees are entirely remote or work from home, are there digital versions, or how do you satisfy that need to post when they're remote?
There are digital versions. As a matter of fact, I was just on a website yesterday, and I don't remember whose it was, where they had it was a link to go to the digital versions of the labor law posters and also all the pamphlets. I actually print out my own pamphlets. I don't pay for them anymore because they're all online. The Department of the Employee Development Department, the edv.ca.gov. If you go there and look up those publication numbers that are in the slides, you'll find all of that verbiage there, and you can just print them out. So yes, you're required. I just sent some of these out for a client. When I send out new hire packets to remote employees now, it is unbelievable how many things I have to attach to each email. It's a lot. Was there another question?
No, that's it. Thank you.
Oh, okay. Safety programs, they're not required by law except in certain industries, and you can find out which industries require you to have a printed and trained safety program at osha.gov, and you'll want to check with calosha.ca.gov because CalOSHA has some additional. In California, we have additional rules. So yeah, you don't have to have one. If it's just office workers, it's a good idea to have one. I think they're great. I think that every job should have a safety, or every company should have a safety program, but some companies don't want to spend the money on it. I get it. And then illness and injury prevention programs, known as the IIPP, that is required. So if you have any employees, you're supposed to have one. I would guess that probably less than 20% of small businesses even know what it is. It just doesn't come up that often, but it's required. Was there a question?
No.
Okay, I'm going to speed through because like I said a little while ago, we're not even halfway through. We're still not halfway through. We're almost we're after 11. You want to keep a separate file, employee file for each employee. Employee files are confidential. Only people with a need to know can look at employee files other than the employee. The employee can look at their own file. They can, it's the next bullet point, you have to give the employee the right to review and they can request copies. You can put in a limited time there, but they have the right to have their own employee file. You keep medical records in a separate file, and as I said earlier, you keep I-9 forms in a separate file or binder. Benefits. If you're going to offer group health and welfare and retirement benefits, you need to have current documentation, and you need to get that documentation to all new hires or somebody who's just coming on to benefits. Lots of people don't go on the benefits right away because they feel like they can't afford them. Employees typically pay for part of their group benefits through payroll deductions. The employer almost always pays for the majority portion. California paid sick leave is administered differently in some cities. This is what I was talking about earlier. Some cities have more sick leave than the state does. So for the state, it's 1 hour for every 30 hours worked. up to a minimum of 24 hours. That will, if you're not familiar with this, that will not stick in your head. Just look it up, California paid sick leave, and you'll get the formula. Okay, questions? Because we're going to jump into firing.
Should we just skip right through this questions, Linda, to get you on track?
Yeah, I think we need to. Okay, there are different types of employment termination. One is a layoff. What does a layoff mean? Well, I'll tell you that in just a minute. Reduction in force, otherwise known as a RIF. Business closure, termination for cause, aka discharge, that's the legal term for it, or what most of us call it, firing. And then at will. Reduced work hours and furloughs, they're not a termination, but sometimes they're eligible for unemployment insurance claims. This happened a lot during COVID, where the companies were reducing work hours and furloughing employees, and they were mostly eligible for unemployment claims if they would have been eligible anyway. Layoffs. This is usually a situation where the company is having some kind of problems, usually a financial problem or a reorganization of some type. The business direction has changed. There might be an economic decline, maybe internally, if they're just not making enough money, or it might be, a global economic decline like we have had during COVID. Post M&A, M&A means mergers and acquisitions. After mergers and acquisitions, some of the jobs become duplicated, and so they have to lay people off. And other mitigating circumstances. Companies have all kinds of reasons for layoffs. I worked at one company from 2006 to 2013. In the first 3 years I was there, we were laying people off every 6 months. And it was just terribly painful for everyone involved. These changes might be temporary and they might be permanent. Some people who are laid off never come back to work. Some people who are laid off because it's just a decline in business. When business comes back up, the company hires them back. The employee is not at fault in a layoff, and they're almost always eligible for unemployment insurance. When I say almost always eligible, there are no hard and fast rules out here. It's the Employment Development Department that determines whether someone is actually eligible for unemployment insurance. So no, you as the employer cannot guarantee it. Reduction in force, this is an organizational change. So it's going to change, sometimes it changes whole departments, whole divisions. Sometimes the company has divested themselves of a particular part of manufacturing and they lay off everyone. When you're laying off a bunch of people at the same time, it's called a reduction in force, and there's a lot of rules around this, and the rules are made so that there is what? No discrimination. So you have to keep, you as the employer have to keep demographics on the people that you're laying off. So you can prove you didn't just lay off all people over age, fill in the blank, anybody who has physical accommodation, all people of color. I mean, there are reasons that we do these things and we document so much. And it's because of the past abuses of companies. So these are generally considered layoffs, and generally, again, eligible for unemployment. And if the numbers are high enough, you will have to follow what's called WARN rules, the Worker Adjustment and Retraining Notification Act. And that means you're laying off a whole bunch of people and you have to provide a lot of additional services. This usually only happens in big, huge corporations. Business closure. This is an employment termination because you're simply shutting the doors. You can't keep employees if you can't run the business. This is a no-fault claim for unemployment benefits. If they're otherwise eligible, they will be eligible for this kind of termination. Termination for cause, this means that the employee did something that you think is wrong for either the company, the department, coworkers, you. So it's a violation of company policy. They're breaking the law at work and in some cases outside of work. They're not meeting performance standards. a slew of behaviors or actions that are not in the best interest of the company or management or coworkers. So sometimes it really is that you have talked to the employee over and over and over and documented it every time. And they can't, for whatever reason, change the behavior that is offensive, that is unsafe, that is in some way not serving the best interests of the company. Number 6, at-will termination. It's like I said earlier, it's a legal. Oh no, never mind. I didn't say this earlier. Maybe I did. 47 states have at-will employment now. This is incredible. When I started in HR, there was no such thing. It can cause long-term ramifications and legal fees and court costs if you the employer have violated certain laws that protect employee rights. So a lot of folks come into a job, they read the at-will termination clause and they go, oh, so you can just fire me at any time with no reason? And the answer, strictly speaking, is yes. And you can quit anytime for no reason. The simple answer is, yep, that's true. The longer answer is, it would be really dumb to just fire people out of hand. I have had managers come to me and say, I can't stand this employee. This employee drives me nuts. How can I get rid of them? Can't I just pull the at-will termination clause? It's like, no, you have to have a legitimate reason. Not liking somebody is not actually considered a legal reason for terminating somebody. So the sample language that should be in your offer letters and your employee handbook. Company ABC is an at-will employer. Either the company or the employee may end the employment relationship at any time for any reason with or without notice. And that's true. It's without cause and without notice. Documentation. I know you've heard this probably most of your life. Real estate, they always say location, location, location. In HR, we always say documentation, documentation, documentation. So legal disputes based on discrimination, those costs can be out of this world, and I'm not kidding. The claims are not infrequent, and I'm not kidding on that either. I have actually gotten letters from candidates saying that they believed, and it's only been 2, but still, that they believed we discriminated based on their age. And then, we had to go through all the applications and see, did we inadvertently? Because we didn't consciously. So the claims aren't infrequent, and the attorney fees often outweigh the eventual settlements paid to the former employees. And I'm not kidding on this either. A lot of the employment law attorneys that I've worked with were in San Francisco, and they were, and this is even a long time ago, charging upwards of $500 an hour. Documentation again. Assess performance standards outlined in your employee handbook. You want to document when the people are not doing their job well, and you also want to document when they are doing the job well. Refer to job descriptions. You need to update these regularly, and most companies don't. They'll just let it go for years. I just recently, somebody retired at a job I was at, and I asked him, do you have your job description? He said, no, I've been here 28 years. I've never received one since. Wow. Okay. So you want to know that the employee is adhering to job expectations. Establish a performance management process, and it doesn't matter how often. It's a real business decision as to how you do your performance management process. And that, employee reviews, pay raises, all of that combined. You want to deliver difficult conversations about poor performance directly with the employee. And you want to provide a plan for how they can improve. You sometimes will ask them to create the plan. I actually think that's a great idea because it gets them involved in the process. Interactions with employees related to performance, you need to consistently document that. And documentation again, it's only as good as the content. So these are some real things that I've experienced at different companies. Pay attention to it and eliminate any language that can be interpreted as discriminatory or retaliatory. And these are real. This manager said, she failed to meet her sales goals because she went out on parental leave. That's a fail. You can't you can't expect somebody who's out on a legitimate leave of absence to have the same sales goals as other people who were there all year. She doesn't align with our company culture and it appears to be generational. I have heard this so many times, I can't even believe it. Their age discrimination is real and it is frequent. It's unclear why he wants to relocate. And at his age, yeah, heard it, seen it. Those managers get pulled into my office when I'm working on site. Ever since he married that woman from Asia, he seems distracted. Are you kidding? These are things that people say. His productivity has fallen off since his daughter died, and I can't tell you, that whole situation just made me sick to my stomach. It went on in awful terms. Protected classes. Before making a final decision about termination, consider if the employee may be part of one or more protected classes. If you haven't heard that phrase, it's a legal term. A protected class means you belong to a class of people who have the same general characteristics. These could be, and then these are in all 50 states. Race, national origin, sex, age, genetic information, color, religion, disability, citizenship status. Cannot discriminate or terminate based on those characteristics. In California, we also add ancestry, sexual orientation, gender identity, AIDS or HIV status, political activities, military or veteran status, victims of domestic violence, assault, or stalking, marital status, disability, whether physical or mental, gender expression, medical condition, or political affiliations. So political affiliations is distinctly separate from political activities in the state of California. Protected leaves of absence. You want to avoid terminating somebody who's on a leave of absence or if they have recently returned to work from a leave of absence. And these would be, they've been out sick, including COVID-19 illness or quarantine, FMLA or CFRA. So that stands for Family Medical Leave Act and the California Family Rights Act. If they're out on one of those legitimate types of leave of absence, whether for themselves or a family member, you do not want to terminate that person. There are times when it can happen, like a business closure. You need to be really careful about this. If they've filed a workers' comp claim recently, parental leave, military leave, any other type of leave that a person is on, you want to check with an HR consultant or an attorney before you decide to lay them off, fire them, RIF them. If you're closing the business, like I said, nothing you can do about it. If a person has made a recent complaint, you don't want to terminate them without thoroughly investigating the reasons for termination. This is where the at-will clause just gets thrown out the window. If they've made a complaint of sexual harassment, safety violations, unfair pay practices, or COVID-19 absences, and anything else they can come up with that they've complained about, you want to go through it with a fine-tooth comb and make sure that you're not just retaliating. 13, this is my favorite one. Consult with an HR consultant or an attorney. If you're terminating and you have any question about whether it's legal, you want to contact an employment professional, an HR consultant or an attorney. The advice you get from a professional may or may not be in alignment with your goals of terminating. This is that, I just can't stand the person, how can I get rid of them? Most will hear your concerns, ask you questions, give you suggestions, and tell you the potential risks if you move ahead. So I can't tell you how often I've said this is a bad idea. You're really, really in deep water here. And they say, nope, I want this person gone. When the CFO of the company, the CEO, the president, people in those, executive chairs come down to HR and they say, here's what I want to do, and I want it done right away. Your job as a business owner is to really clarify the reasons. My job as an HR professional is to make sure I've asked all the right questions and I have informed the person wanting to terminate an employee without good cause, without a legitimate reason, what the risks are. 13A, termination tasks, final pay rules. There are many. The rules are really not many, but the rules are really specific. California, much more stringent than most states. You want to look up final pay rules. Just Google it. I'm telling you, almost everything in these slides, you can just Google it by the phrase. Final pay rules. Notice to employee is to change in relationship. That's the actual title of the form. It's the California Labor Code. It's required when you terminate someone to hand them this notice. And it just says whether they voluntarily quit and on what date, whether you discharged them, fired them, and on one date, whether you laid them off and on what date. It's required. The employee doesn't have to sign it. It's just you have to notify them. Notify all benefits providers, otherwise they're just going to keep charging you. Collect equipment, files, cell phone, credit card, anything else they have that belongs to the company. Collect that before they walk off the premises. You want to deactivate all network access. Yes, employees who are unhappy about being fired, which is most, will try to get back into their email so they can slam the company to all their friends at work. Obtain passwords to subscriptions and work in progress, and then notify that manager and coworkers for reassignment. Make sure that their work isn't just dropped. And then you always want to have a witness in a termination meeting. Why? So that the witness can verify that you didn't say anything discriminatory. All right. I know I sped through that. I'm sorry. I'm just so attentive to the time frame. And I want to make clear also that this presentation is not meant for you to have every single thing. It's to give you the broad overview. And because I've been doing this for getting up there close to 3 decades now, the stuff that I know can't be put into all the slides. There's no way for me to communicate all of the experience that it takes to get to make certain really sound judgment calls. But this is a good start. It's a good beginning. And I encourage you to do your homework as business owners or as office managers, as HR directors. My job as an HR professional never ever stops in terms of research. I'm guessing I probably read and research looking for answers and even just looking for new questions about at least a third of my time, at least a third. That may sound ridiculous, but it's that complicated now. When I started in HR, I thought it was a great job, and I thought, oh, I love this work. I'd worked in law offices for years, and I thought, oh, this is so great. It's so much in alignment with it. And yet it has all the personal stuff that I really like, the communication, the meeting people, working with people, making their jobs better, making the companies better. And then it got so complicated. I'm telling you, by the mid 90s, I was thinking, wait, why did I get into this? And then it came back around in the early 2000s, sort of, okay, well, I've, caught up with the momentum of the changes again. This was after the dot-com bust, and I'd worked in technology companies and laid off literally hundreds of people. When I worked at Boeing, I was part of a team that laid off 12,000 people in a single week. It's astronomical how these things have changed. So I just encourage you to continue asking questions, continue doing your own homework, and honestly, Google everything and then ask a professional, because what you read is not always the truth. I suggest that you get on Cal Chamber. There's a thing called HR California. If you're not a chamber member, go there, look for information. Keep looking at the SBD newsletters because the trainings are phenomenal. I go to them for different pieces of my business that I need more information